Members of the jury.
Taylor's blood is on the defendant's hands, both in the literal sense that the swab Deputy Rowling took retrieved her blood off of his hand the next morning, and the DCI analyst or criminalist determined that was Taylor's blood, and also in the figurative sense, and that the defendant is clearly responsible for Taylor's death. I want to go through a timeline of some important events that you learned about during the course of this trial. Then we'll talk about some of the instructions in law and how those facts apply to each charge of this case, and some different questions or different thoughts you might have regarding how the law applies to this case. I'm not going to read the instructions to you. Obviously, Judge Latham just did that. You're also going to have the instructions to bring back with you in the jury room. 11:34 p.m. Taylor sends a text message to Nick Seaman saying, "If I get killed, it was Chris." You remember we had the screenshot from Nick Seaman's phone. We also had the Facebook returns from both Mr. Seaman and Taylor. Remember that return showed that the message was deleted off of Taylor's phone. Now, whether that was Taylor deleting it herself because she was scared of the defendant fighting it, or whether the defendant deleted it after Taylor had died or during the altercation, that we're not sure of. At 11:35 or sometime after the message to Mr. Seaman, she also contacts Mike Holland about getting picked up. Mr. Holland was drinking that night, wasn't able to, but again, Taylor's reaching out for help at this point because she clearly knows that she's in danger. At approximately 1:42 a.m., so sometime between the Holland calls and 1:42 a.m., we know that Taylor is likely deceased by this point. The defendant crashes his Impala just outside the weather station. And again, we know that time from the footage outside the weather station. We heard that from Mike Lemon. I did include exhibit numbers for a lot of the evidence that I'm going to reference. You're going to have all the exhibits back with you when you're deliberating, as far as all the video, all the pictures, all of the physical items of evidence. So I'd encourage you to go through that as well. 12 minutes later, Lieutenant Leonard arrives on scene. He observes the defendant as likely being intoxicated. He also finds this knife, Exhibit 29, on the floor of that Impala on the driver's seat. And again, that was later determined to have Taylor's blood still on it at that time. If you remember, when Lieutenant Leonard arrived on scene, it was a very rainy night, which is why you likely don't see a large amount of blood on that knife. When Lieutenant Leonard first saw the knife, he had no idea about where that knife would go. He thought it was, again, a relatively routine OWI investigation, removed the knife for his safety and the defendant's, set it on top of the vehicle, clearly exposed to the rain. So it's likely that that knife had a lot more blood on it before that point. But again, Lieutenant Leonard was not investigating a homicide at that time. He observed the defendant to be barefoot, which at that time he interpreted as evidence of the defendant being intoxicated. It's also evidence of the defendant potentially leaving the apartment in a hurry, didn't have time to put his shoes on. At 2:36 a.m., Deputy Raby does a welfare check at the 105 Crestview address. He knocks on the door, I think he said 2 or 3 times, I don't remember the exact amount. No one answers. He clears that call and moves on with his day. Meanwhile, at the hospital, the defendant starts making concerning statements to Deputy Turner. And that's found on Exhibit 1, which is Deputy Turner's body cam. He tells, I think it was the nurse that was attending to the defendant, asks, "Was I covered in blood?" He asked Deputy Turner to again check on the apartment to see if Taylor's okay, and then tells him that something in my mind makes me feel like I did something. Even if the defendant didn't remember what happened on March 13th and 14th in the witness stand. At this point and throughout this investigation, he certainly remembered what had happened and what he did. He goes on to say, I have these pictures in my head that I beat her with the baseball bat, and acknowledged that was the same bat found in Exhibit 23. I'm not going to hold it up because I don't think it's secured in there all that well. I don't want it to fall out. And then he starts saying, and then he kind of stops. He says, if anything that I did that's going through my head, and then trails off. After seeing the evidence, where do you think the defendant's mind was going with at least the beginning of that statement? And then at 4:11 a.m., Taylor's body is discovered by Deputy Slagle and also Lieutenant Leonard. And then 9:57 a.m. or later that morning was that interview with Detective, now Deputy Rolling. We also heard from Detective Alex Grease. He documented the scene, collected evidence from the scene, and facilitated getting evidence to the DCI lab for DCI testing or DNA testing. I went a little bit out of order, but he also took swabs of suspected blood stains from all over the apartment with the assistance of Sergeant Wall, who you did not hear from. We heard from Dr. Hari. She's the Scott County medical examiner. She ordered the autopsy. You heard her testify that that's essentially her role was to investigate suspicious deaths and when appropriate to order that autopsy. She also prepared Taylor's body for transport to the state medical examiner. And in doing so, she placed paper bags over Taylor's hands and also properly secured that body bag. So we know that her body was not tampered with between leaving the scene and getting to the state medical examiner. Where her autopsy was done by Dr. Dennis Klein. You've got access to the autopsy report, which is Exhibit 13. He talked about the extensive injuries that Taylor's body had on it. She had 23 stab wounds from a screwdriver, 17 stab wounds from a knife, and multiple blunt force injuries likely inflicted by a baseball bat. We can't give you an exact number based on the injuries of how many times Taylor was struck by that baseball bat. The defendant, in his interview with Detective Rolling, estimated it was maybe about 6. From the evidence presented by Dr. Klein, that would be a low number based on the injuries that she had. He also told you that her cause of death was multiple blunt and sharp force injuries, which I don't think we needed a medical doctor to tell us based on the photos that we saw. And the manner of death, as he said, was homicide. That's not a legal determination. It's just a determination that someone inflicted this death on Taylor. I want to talk about some of that interview with Detective Rolling. And like I told you before, you're going to have access to all this back in the jury room. I'd encourage you to rewatch this interview. But I want to show you a couple different clips. And you can kind of break the interview up into 2 different parts. We have the first part, the first story the defendant says, and then he says, oh, I made all that stuff up.
Okay, I'm going to be honest with you. I don't know what happened from the time that we went to bed to the time that I hit her with the baseball bat. I kind of made up that stuff in between.
That's important. It shows the defendant knows he did something terrible the night before. It shows that, at least for the first part, he knows he's got to make up a story to try to get out of that. That first story is not important in explaining what happened. You heard Detective Rolling talk about how the first story that he told didn't line up with the evidence on the scene, specifically where they found blood pools and where they knew Taylor bled at. The second story, however, did. I don't think Detective Rolling actually testified to that, but again, review that second story that the defendant told. Essentially, all of the major components fit within what was found on the scene. We talked about beating her with the bat by the door as one example. Clearly, that certainly fits with what we saw on scene, where we saw Taylor's body and the injuries that we saw. You remember at this point, Detective Rolling essentially starts the the interview over with the defendant, because at that point he says everything I made up, so he starts over.
All right, let's bring in our guest for this hour. Still with us, criminal defense attorney Josh Schiffer. Also joining us now, criminal defense attorney Jack Rice. Jack, great to have you on. So happy. I know you were in court. This is what happens to trial attorneys. Let me start with you, Jack, because I thought the state started off strong to say Taylor's blood is on the defendant's hands. That's a strong theme or thesis, and then says literally and figuratively, and then just starts kind of reciting the evidence. What are your thoughts so far?
There's something called passive voice, Your Honor. And passive voice is basically where you say something happened, but you don't talk about what happened. Well, the problem that we have here is that Chris stabbed her 23 times with a knife. Chris then picked up a screwdriver and shoved it into her body, pushed it into her body, slammed it into her body 17 more times, and then he picked up a bat. Where's that? Where is the outrage? Where is the repulsion? Where is all of the things that all of us would feel where you beat somebody until they're unrecognizable in death? We need to hear this because this is what this jury should hear. Frankly, this is what the family of this young woman deserves to hear as well, in the worst sense possible, but you have to memorialize this so they viscerally as well as intellectually get it.
And Josh, the details are gruesome. I mean, he starts with the fact that there was a text from the victim that said, hey, if something happens to me, guess what? Chris did it. And then after that foreshadowing, 23 screwdriver wounds, 17 knife wounds, multiple blunt force injuries, probably by the baseball bat that Chris talked about with the police. And then he keeps changing his story. Are these facts enough for a jury to convict in your mind?
Absolutely. And remember, we heard the testimony from him. And you know, there's so many recordings. There's not really a question in my mind as to what happened. And I respect the defense for trying a mitigation-based defense. But what Jack's talking about with this prosecution closing is dead on. You know, I hate to say that turn of phrase, but the state has what we call righteous indignation. And that's one of the most powerful tools any litigator has when trying to advocate one position or another, because the facts of this case are horrifying. This was a mutilation of a beautiful 31-year-old with a knife, a screwdriver, and a bat. The defense has to do with lack of memory and substance abuse and deflection. The state doesn't want to oversell. The state shouldn't over-extrapolate or exploit this. But the jury deserves to hear that passion.
That passion, the jury deserves to hear it. The facts are on the side of the prosecution, in my opinion, but I agree with both of you. And if you're trying cases like this, you really can't help but the passion takes hold of you because of the gruesomeness. Stand by, gentlemen. We're going to take a break. Of course, when we come back, we did hit the pause button. We'll get you right back in where we left off with the closing arguments in Iowa. Stay tuned. We are in Iowa nearing the end of the murder trial for Christopher Behal. He is charged in the brutal stabbing death of his girlfriend Taylor last year. Police were alerted to her body when Behal requested them to conduct a welfare check because he said he had, quote, visions of violence. Let's get you back into court now. We're listening to the prosecution's closing argument. Those are still going on, but we did pause it. We're going to bring it to you. Let's go back in.
From you laying down.
Yes.
The next thing you remember is hitting over the bat.
Yeah.
Where did that happen?
In the living room. In front of the couch area.
It looks like I didn't place my video very well there, but the defendant in this interview remembers waking up and hitting Taylor with the bat.
That's the only thing I could think of is why, like, something happened. It's like maybe she said something. I don't know. I have no idea because all I remember is waking up and I was hitting her with a bat in the living room. I don't remember anything before that other than laying down.
defendant even goes so far as to show how he hit Taylor with the bat by demonstrating the chopping motion that he used.
When you hit her, was she facing you? Was she facing away?
I think she was facing away.
Okay. Where was she at? Was she standing, kneeling, laying down?
I think she was trying to go for the door.
So do you think, was she like standing or?
No, she was on the ground, like either crawling or kneeling.
So you said that the next thing you remember is hitting her with the bat. Are you left-handed or right-handed? You're right-handed? Okay. So, do you know how, like, do you remember how you were swinging it? Like,
I think it was just like a chopping motion.
just like straight up and down it? Okay.
The defendant even explains why he stopped swinging the bat. If you remember, he stopped the bat because Taylor stopped screaming. Whether the screaming stopped first or whether he stopped swinging first, not entirely sure, but that was his explanation.
When did she stop screaming?
When I stopped swinging the bat.
And do you remember, did you have to go get the knife from someplace, or?
I just remember having the knife and stabbing her. I don't know where I got it from. The only thing I know is that the knife, the last place I knew where it was before all of this was in the kitchen, drying next to the sink.
So you said she stopped screaming when you stopped swinging the bat. And then after that, you stabbed her. If she stopped screaming, why did you stab her after that?
I can't.
And my clip cut off a few seconds early, but the defendant goes on to explain that he at least gives one possible reason why he might have stabbed her, and that was because he already did as much damage as he did, he might as well put her out of her misery. And the state acknowledges that there is some room there for the defendant to say that wasn't admitting why he stabbed her, but why do you think he said that? When the defendant doesn't remember something, just doesn't remember, period, he says that to Detective Rowling. Like with the screwdriver, he admits that he doesn't remember the screwdriver and he doesn't try to fill in those gaps. So when he tells you that he might have stabbed Taylor to put her out of her misery, that's the defendant telling you that he stabbed her to put her out of her misery. We heard from DCI criminalist Stanton Freidlinger, is I think how you say his name. The exhibit is 11C that you'll have back with you. His testimony was essentially that Taylor's blood and DNA was found all over the apartment. I didn't list every single tent where her DNA was found because you saw the pictures, you heard the testimony, it was all over that apartment. It was on the knife that was found on the defendant's vehicle that we've already talked about. It was on the baseball bat that we talked about, and it was on the screwdriver. The next day, it was also found on the defendant's right hand. Also the defendant's shorts. I want to talk about what is evidence. It's a term that I think we take for granted when we talk about hearing evidence or seeing evidence, but there are instructions on that. Evidence is testimony, so what you heard people testify to throughout the course of this trial, that's evidence. That's exhibits, that's all of these, who our court attendants done a very good job of organizing. I think you probably saw them a few days ago when they were all over the table. So that would include pictures, the body camera footage, security footage, the actual items. You even got the blood swabs. Those are all exhibits that you'll have to take back with you to deliberate over. It's also the defendant's statements during the Detective Rolling's interview. And that's found in instruction number 18. So the interview that you heard with Detective Rolling, you can consider that as evidence, just as you can consider his testimony that he made in that chair earlier today. The instructions also talked about direct versus circumstantial evidence. And essentially, the law does not make a distinction between those two things. It's up to you to decide what weight each piece of evidence has, whether it's direct or circumstantial. You've got an instruction on reasonable doubt, which, apologize, I didn't get the number up there, but it is in your packet, I promise. I'm not going to read the whole instruction to you. It's a fairly long paragraph. The operative term there is firmly convinced. If you're firmly convinced of something, you have no reasonable doubt. Like we talked in jury selection, that is not beyond all doubt. It's firmly convinced. Let's talk about the charges. We have 2 counts. Count 1, murder in the first degree. Count 2, domestic abuse assault with intent to cause a serious injury. Each one of those counts has what are called lesser included offenses. So under count 1, murder in the first degree, included in that is murder in the second degree, voluntary manslaughter, and involuntary manslaughter. And you can think of it as more or less a ladder. And we're going to start at the top of the ladder, and you're instructed to consider murder in the first degree first. Only if you find the defendant's not guilty of murder in the first degree, then you move to murder in the second degree. So if you find he's guilty of murder in the first degree, your work on count 1 is done. You don't have to go any farther than that. After count 1, then you'd move on, after the murder first degree, then you'd move on to murder second degree if you find him not guilty of murder first. And then from there you go down to the 2 manslaughter charges. And then under count 2, the 3 lesser included offenses are assault with intent to inflict serious injury, domestic abuse assault, and assault. Murder in the first degree has 4 elements. This is called the marshalling instruction. And this is essentially where you can kind of check off whether the state has met all the elements. It's got 4 different elements. First, the defendant stabbed Taylor Escontrias with a screwdriver and or knife and or baseball bat. Number 2, that as a result, Taylor died. Element 3, that the defendant acted with malice aforethought. And element 4, that the defendant acted willfully, deliberately, premeditatedly, I think I said that correctly, and with a specific intent to kill Taylor Escontrias. I want to talk about each 4 of those instructions, or each 4 of those elements separately. So let's start with element 1. That the defendant stabbed Taylor Escontrias with a screwdriver and or knife and or struck her with a baseball bat. What evidence do we have that the state has met its burden on the first element? Well, first, we have that he had one of the murder weapons in his possession when he first encountered law enforcement, that being the knife. He had access to the other 2. The other 2 were located within the apartment where the defendant admitted both today and back with Deputy Rolling that he lived. He had Taylor's blood on his right hand and clothing. He clearly had knowledge of Taylor's injuries. The defendant can say he did.
All right, the prosecutor going through all the different pieces of evidence and the way that the jury's going to have to consider it, the basic definitions, direct versus circumstantial. And he's talking about the fact that this defendant does face the lesser included charges. So this jury's going to have a lot of choices. We're going to talk about that a little bit later on, but we'll hit the pause button, take a break. When we come back in for more of the closing arguments. Grieving widow or mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder. It's a whodunit Hollywood story. But will there be a twist that no one sees?
The Celebrity Stylist Murder Trial. Today, only on Court TV.
We are watching closing arguments in the Visions of Violence murder trial playing out in Iowa. Christopher Behal is facing life in prison if the jury believes that he intentionally stabbed and beat his girlfriend Taylor to death just last year. Before we head back into court, let's bring in criminal defense attorneys Jack Rice, Josh Schiffer. Josh, I'm telling on you, we're all texting during these closing arguments, and he's going through the murder in the first degree plus the lessers, which is second degree murder, voluntary manslaughter, involuntary manslaughter, and you just said, I don't like this. Why not?
It's the demeanor. And I don't mean to criticize a case where the state obviously has a strong advantage. The defense is limited into the kind of evidence that they can produce. There's certainly a lack of memory, but very strong physical evidence in this case. And I believe, given the nature of the charges, this is death. This is asking a jury to be part of sending someone in their own minds. They realize this guy may never walk free again. And I believe the state is more effective when they inject some passion. The completely dispassionate reading of technical printouts. It would be more exciting for me than watching what this very nice district.
And Josh, we may have lost you. Weigh in, Jack, because I want to know, do you think that his story of not remembering what he told the detectives and his testimony, and I may have lost both of you. All right, what we're going to do, let's go back to the state for more closing argument right where we left off.
With Detective Rowling, and also his conversation or statement to Deputy Turner that he had knowledge of Taylor's injuries. And how else would he know about her injuries unless he inflicted them? We've got no evidence of an intruder or anything of that nature that would point to anyone else. Like I said, we have the statements at the hospital and also with Detective Rowling. We also know that Taylor was frightened that night, again, due to the phone calls and text messages to her friends that you heard about. Specifically, if I get killed tonight, it was Chris. That was a direct quote from a message to Nick Seaman. It's also important to note that the defendant does not deny killing Taylor. He didn't deny on March 14th, 2024, and he didn't really deny it in his testimony today either. Members of the jury, there is no reasonable doubt that the state's met burden 1. You should all be firmly convinced that element 1 is established beyond a reasonable doubt. Element 2, that Taylor died as a result of being stabbed with a screwdriver and or knife and or hit with a baseball bat. What evidence do we have of that? Well, we have Dr. Klein's testimony. He talks about her injuries, her being stabbed 40 times with the screwdriver and the knife collectively, and also multiple blunt force injuries, again, likely inflicted with that baseball bat. He opined that the cause of death was multiple blunt and sharp force injuries, which, as I alluded to earlier, I think probably anyone with common sense could probably have established that as well, just by seeing those photographs of both the scene and seeing that the injuries documented from that autopsy report. The state has met its burden on the second element as well. And to be quite honest, there isn't much argument that the state has not met its burden on these first 2 counts. The fighting issues are counts 3 and 4, so let's talk about those. Third element, keep saying counts, be the third and fourth elements. Third element is the defendant acted with malice aforethought. Luckily, that is defined in our instructions. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another. It's out of hatred or with an evil or unlawful purpose. This is all taken from the instructions. This is not me giving you my opinion. This is from the instructions. It can be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. And it only requires such deliberation that would make a person appreciate and understand the nature of the act and its consequences. Similarly, malice aforethought is a fixed purpose to do some harm which exists before the act is committed. It does not have to exist for any particular length of time. So let's talk about the unlawful purpose, again, from the instruction. Well, the evidence showed that the defendant hit Taylor with a bat as she was trying to escape the apartment, as she was likely trying to escape the apartment. She was stabbed in her throat area after her screaming stopped, again, once the defendant stopped swinging the bat. There was no lawful purpose for doing either one of those things, and I'm not saying those are the only two things. I'm just trying to illustrate points that I think there's a lot of unlawful purpose that happened in that you heard about throughout the course of this case. You can also consider the acts and conduct of the defendant and the means used to do that unlawful purpose. Again, we have 40 stab wounds plus the blunt force injuries. Some, as Dr. Klein testified to, were with severe force. We cannot quantify that, but he did make a distinction between severe force and moderate force. A lot of these had severe force behind them. The assault took place throughout the apartment. That shows that this is not something that was done over a short period of time, but a relatively long period of time. It's going to take time to inflict that many wounds over that many different areas of the apartment. And again, it only requires such deliberation that would make a person appreciate and understand the nature of the act and its consequences. I put this up here again because this is what we call a reasonable person standard. So it's not whether the defendant appreciated, it's whether a reasonable person would have appreciated it. Clearly, a reasonable person or a person would appreciate and understand the nature of the acts and its consequences, as you heard about over the course of the last week or so. He switched weapons at least 2 times because he used 3 different weapons. And then the deleted messages, and I put a question mark behind that. Does it show that the defendant understood what he did and needed to cover up his tracks by deleting those messages? We know that the defendant knew that there was no passcode on Taylor's phone, so he would have had access to that. But again, it also could have been Taylor deleting the messages so that he didn't see them and perhaps cause more anger or cause the assault to get worse. We don't know that. We do know that he hit Taylor's phone. If I remember correctly, the phone was found on the bed underneath either a pillow or a blanket. I don't remember which. I think it's safe to assume that Taylor did not put her phone there. You saw how bloody that phone was from the photographs. Would have been the defendant putting the phone there after Taylor was either incapacitated or after she had died. And after he killed the defendant, or after he killed Taylor, the defendant fled the scene. That's an important fact because it shows the defendant understood exactly what he did and they knew he had to get away so the cops didn't get him. You heard that statement in Detective Rolling's interview. Now, I understand that that's after the assault would have taken place, but unless the defendant all of a sudden came to after the assault and realized what happened, that shows what the defendant's likely state of mind was during the assault, and that he would have understood what he was doing as he was beating Taylor to death.
Let's bring in criminal defense attorney Jack Rice. Give me your last thoughts about the state's closing thus far, Jack Rice.
Murders are traumatic. Murder scenes are traumatic. Murder trials are traumatic. Closing arguments are traumatic. Being on a jury is traumatic. And the thing is don't run from that because this is all true and it all feels horrible. And you have to be able to sit with that. It's simply a fact. And I'm afraid that it doesn't feel like that. I appreciated what he did, by the way, when he said, you know, when you're dealing with a first-degree murder, you start with the first-degree murder. And here's how you do it. You run through that. And by the way, when you've decided that first-degree murder has been proven, and we've proven it, you're done. That's it. You don't have to go any further. And you could have said that.
Yeah, I agree with you. All right, a terrible, tragic case. We're going to pause it there. Thank you, of course, Jack Rice and Josh Schiffer for joining me. We'll have more closing arguments in the Visions of Violence murder trial. For Christopher Behal, joining me, Michael Ayala, up next.
Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. Court TV is following several big cases. First, in California, the LA District Attorney says he's prepared to go forward with the resentencing hearing for Eric and Lyle Menendez and the murder of their parents. But he does emphasize he does not support it.
Also in California, the state is close to wrapping up its lengthy case in the celebrity stylist murder trial of Monica Cementelli.
And in Iowa, just hours after testifying in his own defense, the jury will soon have the case against Christopher Behal in the Visions of Violence murder trial. Behal faces life in prison for the murder of his girlfriend, Taylor Escontrias. She was found brutally stabbed and beaten to death in the couple's apartment in March of last year.
On the stand today, Behal insisted that he didn't remember a lot of what happened that night, including leaving the apartment. The state even pushed him on the two different stories that he told detectives about the murder. Closing arguments are currently underway. The state is still presenting. Let's go back into court.
On there, again, the defendant, he pushed back on this when Mr. Jones was questioning him this morning. But review that clip. The defendant says that he debated on if he was going to lay down, and then was like, no, then the cops are going to get me. In that interview, the defendant tells you that's what he's thinking. And again, it shows he appreciated and understood the acts and consequences of what he had just done. It also shows that he's able to form specific intent. Again, you need to project that backwards just a little bit, because this is after Taylor died. But if he's understanding what he did after Taylor's had died, he certainly understood what he was doing while he was inflicting all of the injuries that you saw evidence of. And then the defendant chose to leave. That was a voluntary act for the defendant to leave, again, as he explained, which is important because it shows the defendant was capable of doing voluntary acts, even if he doesn't remember all the details necessarily. Going on to malice aforethought, which is a fixed purpose to do some harm, which exists before the act is committed. It does not have to exist for any particular length of time. Again, the assault, I'm starting to sound like a broken record because a lot of these apply to multiple counts, but the assault took place with multiple weapons over multiple areas of the apartment. The defendant admits to stabbing Taylor's throat after seeing how injured she is. And even if you accept that the defendant did not know what he was doing up until that point, he said that he came to, saw Taylor injured, and then he decided to put her out of her misery. Iowa law does not recognize a mercy killing or anything of that nature. The defendant could have called 911. He could have rendered first aid of some sort. But no, what does the defendant do? He decides he's going to put her out of her misery and stab her in the throat. There's an instruction, and this is a direct quote, that malice aforethought may be inferred from the use of a dangerous weapon. And you have dangerous weapon also defined for you in the instructions. A knife is a dangerous weapon. A screwdriver, when used to stab someone, is a dangerous weapon. And certainly a baseball bat, when you're using it to beat someone, is a dangerous weapon. So you can use the fact that the defendant used a dangerous weapon, let alone three, to infer malice aforethought. Members of the jury, the state has proved beyond a reasonable doubt that the defendant acted with malice aforethought. Let's move on to the fourth element. That the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Taylor Escontrias. Okay, we can look at the nature of the crime. Clearly this is a willful action. This isn't something that happened by accident. Despite what the defendant may want you to believe, this is not the actions of someone that's so drunk that they don't know what they're doing. 3 weapons, multiple areas of the apartment, does not render aid. And again, like malice aforethought, does not need to exist for any determined amount of time before the act. So that can be an instant, it can be a second, it can be planned for weeks. Obviously, this is not a case where we have the planning or the premeditation for weeks or days. We're talking hours or minutes at this point. Willful, deliberate, and premeditate, I think I might have misspelled that. There are instructions on that as well. Willful is by fixed design, on purpose, not accidental. Nothing about this crime was accidental. She had 40 stab wounds, multiple blunt force injuries. That does not happen by accident. Deliberate is defined as to weigh in one's mind, to consider, contemplate, or reflect. This is where you need to make some inferences based on the evidence, because we can't exactly say what was going on in the defendant's head. But there was certainly time for the defendant to deliberate. In between any one of those 40 stab wounds or the baseball bat strikes, the defendant could have likely deliberated on what he was doing. He likely deliberated when he switched weapons. Why does one switch weapons? Because the one you're using isn't working well enough for whatever you're trying to do. Otherwise, if the defendant wasn't thinking, there'd be no reason for the defendant to switch weapons. And then to premeditate, to think or ponder before acting. Again, this does not need to exist for any amount of time. At some point during the 40 stab wounds, multiple bat strikes, the defendant would have had time to think or ponder before he was doing that. And again, even if you take the defendant at his word, when he says he comes to and decides that he's going to stab Taylor to put her out of her misery, that's premeditation right there. This assault, as I stated before, it took time to complete. Plenty of time for the defendant to form the requisite mental state that he needs to be convicted for murder in the first degree. And I got ahead of myself a little bit with some of those slides, but the state has met its burden on the 4th element, that the defendant acted willfully, deliberately, and premeditatedly, and with a specific intent to kill Taylor Escontrias. Why else would he have stabbed her 40 times and beat her with a bat? The defendant is guilty of murder in the first degree. Now, I suspect you'll hear about the intoxication defense a fair amount from the defense when they give their closing arguments, and I wanted to talk about that intoxication defense. You'll find that in instruction 39. It does not excuse or aggravate guilt, so it is what it is. The requisite question is whether the defendant had sufficient mental capacity to form specific intent. I want to go back to the elements. Then I'm jumping around, but I want to go back to the elements. As I told you before, this is what the state's required to prove for murder in the first degree. As we talked about in jury selection, the state's not required to prove motive. There was not a lot of evidence on motive, but we're not required to prove that. The defendant did make some statements about the relationship being kind of rocky, right around the time this happened. Whether that was a motive or not, nobody knows at this point except the defendant and perhaps Taylor, and Taylor can't tell you, obviously. We're also not required to prove that the defendant remembered what he did. Even if the defendant has no recollection of what happened, as he testified to today, we're not required to prove that. You heard Dr. Doyle's testimony. when someone's having a blackout, it doesn't necessarily mean that they don't know what they're doing, that they're robots without any control of their actions. He said that it blocks your brain from forming long-term memories. That's what a blackout is. It doesn't mean that the defendant didn't know what he was doing when he was doing it. It just means that he doesn't remember doing it. Not remembering doing something is not a defense. Intoxication is. And again, the specific or the critical question is whether he had the requisite mental capacity to form specific intent, and that's the specific intent to kill Taylor. Again, let's look at the brutality of the crime. Number of weapons that he used, moving about the apartment. One thing we haven't talked about is the injuries on Taylor were in high-value areas. This is not someone that's so drunk they don't know what they're doing, and they happen to be swinging a bat around and it accidentally strikes Taylor. These are wounds clearly intended to inflict major damage on Taylor. There are many wounds around her head. You saw the screwdriver injuries on the back of her head where you can actually see the crosshatch, and also on her hands, likely as Taylor was trying to block the screwdriver from hitting her. The knife wounds, as the defendant told you in the interview, were in Taylor's neck. Again, this is not someone that's so drunk that can't form rational thoughts. The defendant knew what he was doing when he was doing this. He might not remember everything, but he certainly knew what he was doing at the time. And again, he also has the presence of mind to flee the scene with one of the murder weapons. And it's a weapon that the defendant admits was used last. We don't know for sure which weapon was used in which order, but the defendant talked about killing Taylor with that knife. He's found later that evening, whether that was minutes or an hour, we're not sure, but he is found later that evening with that same knife that he had missed killing Taylor with. So he knew to leave. He knew to bring at least a murder weapon he had in his hand. Now, nobody's saying this was the perfect crime, and maybe if he was completely sober, he would have thought to bring the other two murder weapons as well, but he didn't think to do that. He just thought to bring the one that he had in his hand. Despite being intoxicated, the defendant had the specific intent to kill Taylor. And not remembering what happened does not mean the defendant should be found not guilty. And again, the fact that alcohol lowers inhibitions does not mean that the defendant should be found not guilty. If there was no alcohol involved, it's likely Taylor would still be here. This is not a question about whether this is something that would have happened without alcohol. Clearly, alcohol played a role in this tragedy, but that does not excuse what the defendant did that night. And it doesn't mean that the defendant did not have the mental capacity to form specific intent to kill.
All right, folks, we're going to take a break here, but before we do, we want to update you on new developments in the Menendez family murders case. Today, Los Angeles District Attorney Nathan Hochman said he does not support the resentencing of brothers Lyle and Eric Menendez, who were convicted in 1996 for killing their parents at their Beverly Hills home in 1989 and then sentenced to life in prison without parole.
We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal. With respect to them, the key issue of exhibiting insight, full insight into their crimes and completely accepting responsibility for their actions, this is where the Menendezes, like Sirhan, also fall short.
The brothers' resentencing hearing will be on March 20th and 21st. Today, Hochman said the former district attorney's recommendation to resentence them was a, quote, desperate political move. Last month, he opposed a new trial for the brothers. Menendez family members who are advocating for the brothers' release issued a statement in response to Hochman today, saying D.A. Hochman broke his promise to listen to us, keep politics out of this review, and look at the full picture of this case, and that Hochman sent a message to victims of abuse to not come forward.
California Governor Gavin Newsom also recently requested a state parole board to investigate if the siblings would pose a risk if they are released. The brothers have submitted a clemency plea to Newsom, who said that he would not make a decision until Hochman reviewed the case.
That's right. Let's take that break now. We're going to get you back inside the Iowa courtroom for more of the closing arguments and the Visions of Violence murder trial of Christopher Behal. Stay here with us on your front row seat to justice.
An Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial. Live coverage today on Court TV.
Tonight, on Closing Arguments, more than 30 years after Eric and Lyle Menendez killed their parents, new evidence has come to light. We're breaking down what's next for the Menendez brothers.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
Before we head back to court, we have this update in the celebrity stylist murder trial of Monica Cementilli. Cementilli is accused of killing her husband, famed Hollywood hairstylist Fabio Cementilli, back in January of 2017.
Her lover, Robert Baker, is already serving a life sentence without parole after pleading no contest in the case. And he could be called by the defense to testify on Monica's behalf in the next day or so. Now, a third confessed killer, Christopher Austin, he pleaded guilty to second-degree murder as part of an agreement to testify against Cementilli. Austin testified for 3 days last week and told the jury that Monica is the one who told Baker about Fabio's whereabouts during a failed murder attempt and on the night that Fabio was killed.
Also last week, a detective with the Los Angeles Police Department testified on direct examination about Austin's arrest and about an informant who was put in a cell with Austin to get information. Today, that same detective was on cross-examination.
Now, the defense pushed back on the detective's testimony, saying Austin never actually said that Monica was a part of the killing.
Throughout Christopher Austin's conversations with you that day, he wasn't holding back, correct? He confessed to murdering Fabio Cementilli. Did he not?
Well, he did hold back on information that we've now learned since he's testified, but no, he did not hold back about his participation and role in the murder of Fabio Cementilli.
So he told you the detail about his killing Fabio Cementilli. The only part he left out was that somehow his new claim in the proffer that Monica Cementilli was somehow the mastermind of the whole thing, correct?
He did not mention that in our interview, no.
The state could rest its case as early as today, and we have heard the defense could call Robert Baker to the stand when its case begins. We'll have to wait and see what happens. I think he's going to take the stand.
I think it's the only shot they have.
Yeah, me too.
Right? I mean, putting her on the stand, I don't think even helps him as much as putting him on the stand.
I would agree. As long as he's going to say, hey, she wasn't involved.
He's a wild card. You never know what he's going to say, right? All right, we're going to turn back now to Iowa, where the state is wrapping up its closing argument in the Visions of Violence murder trial of Christopher Behal.
With intoxication, it's not a defense to murder in the second degree, and that's in your instructions as well. So even if you accept the defendant's intoxication defense, it's not a defense to murder second degree, which is the next level below murder in the first degree. The instructions tell you that no amount of intoxicant taken voluntarily can reduce second degree murder to manslaughter. So in other words, if you're convinced, if you're firmly convinced that the defendant voluntarily consumed alcohol, you're not able to go from murder in the second degree down to the manslaughter charges. How do we know whether the defendant voluntarily consumed alcohol that night? You know, I understand addiction is a terrible thing, but even though the defendant has alcoholism, and we're not disputing that, the defendant made a choice that day to consume alcohol, as he told Detective Rowling. He says, I remember making the choice to drink. With murder in the second degree, that's essentially the same as murder in the first degree, except the fourth element is crossed off. So the first three elements are the exact same. I'm not going to go through each one of those elements again. Just know that it's the only difference between murder first and murder second is that fourth element. Moving on to count 2, which is domestic abuse assault with intent to cause serious injury. Again, we've got 4 elements. The first element was on or about the 13th day of March 2024. The defendant did an act which was meant to cause pain or injury, result in physical contact, which was insulting or offensive, place Taylor Escontrias in fear of immediate physical contact, which would have been painful, injurious, insulting, or offensive to Taylor Escontrias. There's a lot of words there. Essentially what it means is for purposes of this case, is the defendant actually hit her with the bat, stabbed her with a screwdriver, stabbed her with a knife. Any one of those things would satisfy the first element. Secondly, the defendant had the apparent ability to do the act. This element is easy as well. We know the defendant had the apparent ability to stab her with a screwdriver, to stab her with a knife, and beat her with a bat, because he actually did. He actually assaulted her with each of those 3 weapons. At that time, or element 3, that at that time, when again he was stabbing her and beating her, the defendant intended to cause a serious injury to Taylor Escontrias. Why else would you do that? There's only one reason to inflict those kind of injuries on someone, and that's to inflict serious injury. And lastly, that the act occurred between family or household members who resided together at the time of the incident. Family or household members is defined as essentially, think about it as a boyfriend and girlfriend living together. They share expenses, they share a bedroom, all of which you heard. This element is satisfied as well. The defendant and Taylor were family or household members at the time of the assault. The state has established beyond a reasonable doubt all 4 of the elements of domestic abuse assault with intent to inflict serious injury. Based on the evidence that you've seen over the last week, the state asks you to return a verdict of guilty to both count 1, murder in the first degree, and count 2, domestic abuse assault with intent to inflict a serious injury. Thank you.